Good afternoon, and welcome to today's webinar. Vann Attorneys, we are so thankful to have an opportunity to share information with you. We hope this is helpful to you. My name is James Vann, and Jim Beck and I are here today together to talk about using LLCs in business, and we're going to be looking at several different ways that those come into being, and that is how you use it. One is sort of what is an LLC. How you might use it when you're dealing with someone who's using an LLC as their business entity, and then some of the advantages of using that in your own business. Little housework before we get there, little homework. If you have questions, please feel free to go to the GoToWebinar control panel on your screen and send those to us that way, or you can send it to us by email at webinar@vannattorneys.com. So again, we would love to hear from you if you have a question or if you just have a comment. So we'll be doing that together. The things we're going to be talking about today, obviously looking at using LLCs in your business and also the advantages. So we're going to just give you a screenshot here of what we're looking at. Doing business with LLCs, what is it? What's the impact? And also looking at the advantages of using those in business. And so, Jim, I think you're going to start us off today looking at businesses and doing business with an LLC and how do we do that. So thank you for your help.
Thanks, James, and thank you all for joining us today. As James said, my subtopic is basically doing business with LLCs. So think of it as a scenario as you are in business and a potential customer comes to you and they have an LLC, you're going to do business with them that way, or a situation where you're doing a transaction with an LLC where you are either purchasing that LLC from another person or you're purchasing assets from an LLC. So there are just some basic things to keep in mind in those situations. So the first thing we're going to talk about is the fact that an LLC is a separate entity. I'll explain a little bit about what that means. Then we'll talk a little bit about what things to consider when entering into a contract with an LLC. And then the last thing I'll go over will be just what does it mean when we talk about ownership? Why is it important in the context of an LLC? So first of all, an LLC is a separate entity. And what that means is it is a legally recognized entity separate and distinct from the owners. The owners are called members. So if I say member, that means someone who has an ownership interest in the LLC, just sort of like a shareholder of a corporation. So an LLC is like a corporation. And basically it's transferable, so the people who own it can pass it on to somebody. It doesn't die with the person. It doesn't really matter, what happens to the person. The LLC can still be in existence. So members can change. The other thing about it is a company can cease to exist. So it can be dissolved. The Secretary of State can dissolve it if certain procedures aren't followed. So the reason some of these things are important is a lot of times a person has a relationship with a person. They enter into a business relationship with a person. Well, they don't always think about the fact that that person's business is actually something different from that person. So we just want to kind of make it clear that you've got to know what you're dealing with and who you're dealing with, and understand that LLC is a legal existing entity.
And Jim, and I can't remember if there's a slide about this, but I figured I'd just throw it out. When you say it's a legal existing entity, it has its own tax ID number, just like a regular corporation does. It generally has its own tax ID number that has to file a tax return. and it's like you say, it's a living, breathing entity in and of itself. It's not the same people. It's not the people that own it.
Right. The LLC can buy and sell. The LLC can be bought and sold. The LLC can own assets. So it's just like a corporation in the context of, it's separate. Now, with that in mind, there are some things we need to think about when entering into a contract with an LLC, or even just considering entering into a contract. Step one is to properly identify the LLC. The easiest thing to do is you go to the Secretary of State and you type it in and search for it, make sure it exists. Now, the reason I kind of make this sort of the top of the list here is, and I've seen it numerous times and it happens every day, a person either thinks they have an LLC or they think the name of their LLC is one thing, but it's actually another thing. So what's important to do is to check up on that person to make sure they're right. Because what could end up happening is you sign a contract with an LLC that's either not the person's who you're dealing with, or it just doesn't exist at all, period, and you've basically got a contract with no one.
Well, Jim, let me ask you a question. Let's say I have a company that I run outside of, obviously, who I am. I have a company, and I send you a contract to do business with your company, and on the application or the purchase order, however I do that, I put on there, let's just say it's James Vann's tree removal, and I put comma LLC, right? So it's James Vann's tree removal, comma LLC. That makes me an LLC, right? Just that, but I haven't done anything with the Secretary of State. So I would I be an LLC if I did that?
No, you would not be an LLC. You're not an LLC unless the Secretary of State says you are.
Got it.
So you would be James Vann.
You'd be sole proprietor.
And you've got from your standpoint, you've got no personal protection of assets because you don't exist as an LLC. You're just a person.
Right.
The other thing is, a lot of times a party you're dealing with might think they're an LLC, but they're a corporation. They might be a partnership. So it's always important to just double check that. Yeah. You want to confirm the name, spelling, the word order, because it could be James Vann Tree Removal, LLC, but there could also be James Vann Removes Trees, LLC. And that's a whole different LLC.
Right.
So always just make sure that's right. And this is a common issue, which is why I keep harping on it. But I've seen it, and I just want you all to be aware of it. So be precise. And that goes on your end as well. If you are a party that is an LLC or even a corporation, be precise when you're preparing your own contracts that you've got your name correct. Another major issue is signatures. Now, when you enter into a contract, it's going to get signed, hopefully. While, of course, there are situations you don't have to sign a contract for a contract to exist, but we're talking about a contract where each party executes it. We just want to make sure those signatures are done correctly. First of all, the party signing that contract's got to have authority to do so on behalf of that LLC. So, step one, determine, does this person have authority? Are they a salesperson for the LLC? They may not have authority. Are they an officer of the LLC? Well, they're going to absolutely have authority. So what you want to do is make sure that a signature on a contract for an LLC has the person's name, signature, and title. When you've got that, you've got all the evidence you need that this person had authority to sign the contract and bind that LLC. When I say capacity, that goes to several things, but the main thing I want you to think about is if the LLC doesn't exist, an LLC doesn't have capacity to sign something. again, so then you'll be dealing with an individual. Remember, details and precision are important. And this goes for pretty much any contract. The little, I got a note there that says witness, notary, and seal. So these are three different things, but if you want to be, very prudent, you'll have a witness who sees the person sign the contract, so later they can't say they didn't. Even better would be to have a notary. A notary notarizes that contract, and that's a little bit more official, and you can use that as strong evidence that a contract was executed and exists. And then the seal, if you see the word seal, what that does is extends the time period where you're allowed to sue if that person breaches. So generally speaking, a contract, you can sue somebody 3 years after the breach. Well, if it says seal beside their name, you get 10 years. So just some other things to think about. And that really applies to all contracts, not just those with LLCs.
And let me just add that one question or one thought, Jim. You're talking about having a witness, or obviously notary helps. If it's a witness, does it matter if the witness works for, let's say, the opposite company to the contract, or does it matter if that witness is an employee of the person who's signing the contract? Does it matter where that witness works and who they're related with?
I think we're at that point. We're talking about the strength of the testimony. I mean, if it's a person who's an employee and works with that person in the company, and they're going to testify, yeah, I saw him sign it, that's stronger than our own person saying they saw it signed. But again, it's someone saw it and someone could testify they saw it signed. Then you're just looking at credibility of the witness.
Mm-hmm. Yeah, that's good. So we got a question that came in. It says, how do you determine if a signatory has authority to sign on behalf of an LLC when they're not an officer? So they're not an officer. How do you know if someone has authority?
That's a good question. I mean, I think the best way to handle that is to ask that person, say, what's your title, what's your role, are you an officer? And then ask them for documentation from, if they're an employee without any real authority, then you need to explain to them, we need someone who can bind this company. We don't know if you're it. Either give documentation that you are, or have a manager or an officer of the company sign it.
Yeah. And, I'm thinking, let's just say you get the contract by email, and then shooting an email back and say, hey, thank you so much, but do you have authority to bind the company or to sign on this? Getting that clarification by email, that's probably better than doing it by verbal. Right. You may have a verbal conversation, but then say, hey, look, I'm going to shoot you an email. I need you to follow back up on that, just so that I have something in writing. And then the other question is, can any employee sign on behalf of a company, of an LLC, to bind them? And that would be obviously no, not any employee.
I mean, they can't. And then if you get into that situation, the court's going to have to determine, did they have authority? Did they have actual authority? Did they have authority in the sense that it was apparent such that it should be binding? And then you get into these legal issues. So the best way to handle it is to get the information from a manager, from an officer, and get in writing a response to your question about, did they have authority to do it?
We had a follow-up question. It says, can you designate an authorized person in the signature line of a contract? So I think what I'm reading at is, can you require a particular person to sign the contract? Absolutely. And presuming that there's a presumption of authority to sign if it's the president or a vice president or something. Absolutely, you can designate someone that they have to sign it. If you know so-and-so is the owner, then of course you could require them to sign.
Right.
I hope if we didn't understand that question right, shoot it back to us and we'll try to get it right. So. Okay,
and the last thing about contracts, and this one is pretty straightforward and brief, but personal guarantees. If you're going to get a personal guarantee, you need a separate signature for that guarantee. So you've got a signature for the LLC by an officer or a manager or an agent, and then you've got another signature for the guarantee. You need the language to be as clear as possible that this person is personally guaranteeing the debt of the LLC. And then the same issues with respect to signing with a witness, a notary, seal, that kind of thing. So remember, 2 signatures if you're getting a guarantee.
And we help a lot of folks on their contracts, their classifications, whatever it may be, whatever they're using with this language. So if you're not doing that, or if you have any questions, we'll be glad to take a look at yours and tell you if you need to have it updated. And thankfully, it's not as expensive as it used to be over the years because of word processing. But as Jim said, if you're not using 2 signatures, you're really setting yourself up for potential issue, number one. But number 2, it costs a lot of money to deal with that in court. If you can nail it out before you get there, it's a whole lot better. So.
Right.
All right, we've got a poll question we want to shoot out to you. So we want you to vote here for us. So do you generally ask for personal guarantees from members or owners of an LLC? So yes, no, or not sure again. So do you generally ask for personal guarantees from members or owners of the LLC? So y'all are doing an awesome job. We're getting in 62% voted so far, so it's moving up. You know, I feel like we're on election night here. We're at 69%. We're almost, actually 77 now. So Jim, we're almost can call this election.
77%.
So if you haven't voted, do so. If you're asleep, don't worry about it. We'll catch you next time. We're going to close it out here in about 2 seconds.
Yeah, I think it's stopped at 77% voted. Okay. 70% of you.
Awesome.
Get a guarantee.
85%.
All right, 85% voted.
So 73% say yes, that they generally ask for personal guarantees. 27% said no. Thankfully, 0 said, or nobody said they weren't sure. So that's awesome that you know. So good job on asking for the guarantees. That's obviously helpful to your business.
Definitely.
Good. Thank you for doing that.
All right, and then a few things on ownership. An LLC can be owned by an LLC, an individual, group of individual. So you want to know you're dealing with the right person. And what I'm getting at is, does the person you're dealing with own this company? It's not always important, but if in certain situations, if you're buying the assets of the LLC or you're buying an ownership interest in the LLC, you better make sure that that person you're talking to is actually the owner. Let's say you're buying the assets of the LLC. The reason that might be important is a lot of times that LLC is going to require either unanimous consent or at least 2/3 before those assets can be sold to you. And if this is some person with 1% of the ownership interest and you're buying assets, you're going to pay a lot of money and have 0 to show for it because there wasn't the approval to do it. So dealing with the right person is important. You're not dealing with, someone who doesn't have the right to do what they're trying to do, if that makes any sense.
One thing that you mentioned here says who owns the LLC. You mentioned another LLC. So in fact, you can have an LLC can own the membership rights of an LLC, right?
Right. So what you're trying to be careful of is all these layers of protection. You want to make sure, is this LLC really just a shell company? Is there any value in it? If you're going to do business with this company, what's your recourse going to be if they, breach a contract or harm you in some way? And if it's LLC after LLC after LLC, probably nothing. So again, you go back to your personal guarantee. You go back to making sure that you know exactly what you're dealing with. just makes life easier in the event of bad things happening.
Right. And then, again, it is legal for an LLC to own either 100% or a part of an LLC. The thing I would encourage is, if that ever happens, if you ever see that, that's not always a red flag that someone's out trying to take advantage of somebody. But it should ask the question, what's going on? Why is it set that way? Could be tax, could be a privacy thing. They don't want to know who's involved in it, but it doesn't always raise a red flag, but you ought to ask the question.
Right, and it's just so you are aware that you might need to secure whatever your deal is with something else,
right,
to kind of cover you in the event of a loss. And then who owns the assets of the LLC? The LLC might own it. The members might own it and either just allow use or lease assets. Another LLC, or anyone. And these are just assets the LLC uses to do its business. So, for example, what if you are purchasing trucks from an LLC? The LLC doesn't actually own the trucks. Well, you're not getting title to those trucks. And it goes also back to, if in the event you got to collect a debt, does the LLC own anything? So what we're getting at is just know what you're dealing with. Try to do the background work before you enter into a business relationship, so you know that if you need additional security, you know that if you purchase trucks, you're going to get those trucks and good title to those trucks. And that's just some things to be prudent when starting to work with a new potential customer or in a new business deal.
Let me ask you a question with the piggy bank that's on the screen. Is that how you get into your piggy bank, or because that looks like it's going to be a permanent opening?
Yeah, it looks like it.
Okay. All right. Sort of continuing the conversation of ownership. Are you dealing with the right person or entity?
Right. And so, again, I think we kind of went over this a little bit about, is Joe the owner of Joe's Trucking, or is Joe just an employee, or does he own Joe's Trucking and Hauling? So again, the right person, again, it's important because of their value, and do you have, any security in case something goes wrong?
So let's look at some of the advantages of using LLCs in business. So we're going to look at the legal effect of an LLC. As we talked earlier, it is an incorporated business. So it shields the owners from personal liability, borrowing anything from some kind of activity by the owners that are just way outside the reasonableness of running the company. For example, if one of the owners gets in his car, after work and decides to go to a bar and gets incredibly drunk and then kills somebody in the car, and they were there by themselves, wasn't a company function, but they're driving a company car, does that create personal liability? It probably would, because of what they did, but obviously if they went out and just had an accident by themselves without drinking, no other bad facts around it, it may not be any personal liability. Maybe a company, could be, just depending on the issues, but the real issue is the LLC shields the owners, the members.
Right. So if my company is owed $100,000 from an LLC, can I go after the owner?
Not if you don't have the personal guarantees. As long as they've kept good corporate records, and they've done everything corporately they're supposed to, that should shield them, right? So again, it shields the owners from any liability, and there are some exceptions, but they're pretty small. It allows for a single or multiple owner, which we talk about some of the advantages. And again, it's like a C corp, and most people are familiar with just a regular corporation or an S corp. They might have heard that over the years. All three of those entities, as a C corp, S corp, and an LLC, have the same shield protection for the owners and officers and directors. They all three are the same, so it shouldn't be an issue there. Some of the tax benefits are of an LLC is that it's treated as a pass-through entity for tax purposes. So let's just think, for example, the corporation makes $1 million In a regular C Corp, the corporation is going to pay taxes on that $1 million, and then from there, it's going to make a distribution or dividend to the shareholders, and again, the shareholders will pay their tax on that dividend. So in essence, you got two taxes, the corporate tax and then the individual distribution or dividend tax. Whereas with a LLC, same facts, the LLC makes $1 million. All of the revenue in that case passes to the members based off their percentage ownership, and then the member pays the tax off of that distribution from the LLC. So you're getting rid of one tax there. As we all know, the tax code has changed a little bit. Thankfully, this has not been impacted. The idea of the pass-through has not been impacted. If your rate changes, again, that might be something going forward that we all wind up looking at is in the last number of years, the LLCs have probably outpaced C Corps or S Corps. Probably, I'm going to guess 5 to 1. But sometimes there are reasons to do S Corp. And again, the difference between a C Corp or S Corp, the only difference is the S Corp is an IRS designation. It's regular C Corp as it's filing with the Secretary of State, but then you apply to the IRS to ask for special tax permission to be taxed as an S Corp, and you get the pass-through. So
right.
Same thing. So again, it allows the flexibility of how the company's going to be taxed. That's the real advantage that most people use, or that's why they like it. And it's a flow-through tool for deductions as well. So for example, if you've got a business that has lost money or has big deductions, those pass through to the members as well. So again, a pretty big advantage. One other issue I know that people deal with a lot of times is privacy. We've had clients over the years ago, you know what, I don't want anybody to know that I've got part of that LLC or that I own it. So this is a great way to own a business and not show up that you own the business. Sometimes, and we haven't dealt with this as much, but I know this exists. If a homeowner is going to buy, say, a fairly big house, that's generally what it is dollar-wise, they might put it in an LLC. Again, they don't want to be known that they own this fairly big, expensive house. Or if there's real estate investors or other types of transactions, and people are involved in it from an investment standpoint but don't want their name attached to it, but say because of political reasons or even just the public knowledge that they've got a part of it. We've got a client who had done some real estate development, awesome individual, up and above board, but just wants to keep their name out of the public record that they're doing that, and that's all legal, you know. I know we've had some times over the past where we've had clients who are well known in the marketplace, and they want to start another business, and they keep it. They don't want that to get out into the business world because it creates a trail, I guess, of whenever they do stuff that the media picks up on it. So they set up an LLC, either use us or somebody else's names to show up as a registered agent, that kind of stuff. And they, their name's never on it, which is nice. So again, it just helps you with that. Also, it helps avoid some scams, identity theft issues, frivolous lawsuits. And I don't know if you remember that lady who won the lottery. I can't remember what state it was in recently. She didn't want to be known. Every state's lottery laws are different, but she did not want to be known. So she, in that case, she could do it under an LLC. Have everybody else's, the lawyer's names on. She's avoiding scams.
Yes, if you win the lottery, form the LLC first. Then tell the lottery people you won.
That's right. Yeah.
Don't do it the other way around.
Call us.
So that it won't be private anymore.
That's right. And then if you got real estate holdings, using LLCs for each piece of the real estate. For example, let's just say somebody's going to buy 5 pieces of commercial property, or even 5 residential pieces of the property, it makes sense to put those in separate LLCs for liability purposes, to hold on to that. So, advantages of others of using LLCs, again, if you set it up correctly, it works out really well, most apart from limiting liability. And you got to keep good records and minutes. You got to file your annual report just like you do any other corporation with the Secretary of State. You got to run it and operate it as though it's a separate entity. So, for example, if I own a separate LLC and it's paying all my personal household bills, all my personal, business, everything that I can imagine, I run through it. And you look at that later, and you go, wait a minute, is that James's personal account stuff, or is that the LLC? It's going to open up questions, right?
Yeah, and then you open yourself up to, well, can we get through that LLC to him personally? And you don't want to do that.
Yeah.
So, like anything else, you got to keep separate accounts, separate everything from your personal in order for that stuff to stay separate from the reach of creditors.
And there are tons of reasons to have the LLC and to use them. There are awesome business and financial and tax purposes or benefits that you get. You just got to follow the rules and, know where the line is. I tell clients, know where the line is, back off of it just a touch so that you're clear from the line, and then operate as hard as you can. Mm-hmm. I'll tell you one quick story. We dealt with this several years ago. We had a client who owed money. Company changed hands within the family. It financially started getting a little bit weak. Thankfully, we had personal guarantees, but we got a judgment on the corporation, and we went to start looking at records. And what we found was that the company was paying all of the insurance bills for like all kinds of family cars, that the company actually bought the cars, but they were titled in individuals' names. And there was no documentation saying that they're doing this because they're officers, directors, or employees. The company basically just bought cars for everybody and paid for them. Mm-hmm. Can't do that. And so we were heading into Pearson and Corporate Bail, and I showed back up the next day to continue looking at documents, and they had a certified check for us for 100% of the judgment. And again, that was a perfect world, but it was awesome. It was a
perfect case, but again, be aware that keep things separate.
Yeah, that's right.
And document what you're doing.
We got one more poll question for you, so that's going to pop up here. So, what would you estimate is the percentage of your customers that now use LLCs as their business entity? So, how many? It's just a guess. What do you think? 75? I think we split it 55, 74, 25, 49. So, tell us what you think. We've got 40. I mean, y'all are doing an awesome job. 60. Y'all are killing it. Thank you so much for voting. All right, we're at 85%. Those who woke up, I think, have voted. So, about 3 more seconds to, and we're almost
100%. There we go.
All right, so the answer is, it looks like the greatest answer is around 25 to almost 49%, 54%, and then it shows up to 50 to 74. So you're starting to see that a lot, and some of them said less than 24%. It'd be interesting to see with new companies that are being developed, that are being started. I bet you that number's going to be higher, but thank you so much. I hope that helps you. You see that number, so hopefully that's helpful. If you've got questions, again, we want to be here to help answer that for you. Hopefully this is helpful for you today, and we really do appreciate you participating. One of the things we always want to do is try to be an incredibly, hopefully, resourceful group of folks for you. We hope you'll follow us on Twitter and LinkedIn and so forth. And also, our next webinar is going to be on Wednesday, April 26th at 3 o'clock. That's on our website. You'll start getting some contact information about that. We'll be talking about non-competes and non-disclosure agreements in North Carolina. Also, once you log off today, you're going to get a couple of questions, survey questions. They're really helpful to help us. So if you would do that, that would be most helpful. We really do hope this has been helpful to you today. Thank you for participating with us, and look forward to hanging out with you again, man.
Yeah, thank you all for joining us today, and if you have any further questions, just shoot us an email.
Thank you.